Hello, everyone, and welcome to this month's webinar, New 2023 Employer Obligations Annual Employment Law Update. This free webinar is available exclusively for our customers enrolled in our subscription services. I'm Stephanie Blicky, the Subscriptions Program Lead for Personnel Concepts, and I'm joined by my co-moderator, Leon Frierson, who serves as our Corporate Accounts Executive.
Yes, hello and good afternoon to all of our attendees. I'd like to welcome attorney Laura Freeman as our featured guest speaker. Laura Freeman is an experienced labor and employment law attorney. She has significant experience in both private practice and in-house legal departments. Her most recent roles at PayPal Inc. and Ansys Inc. involved advising HR and business partners in the U.S. and worldwide on a broad range of employment matters. This included counseling internal clients, managing a portfolio of employment-related claims and litigation, managing teams of in-house and external attorneys, and driving complex legal projects.
Thanks for having me, both Leon and Stephanie. Welcome, everybody. Thanks for the introduction. As Leon said, I'm a labor and employment attorney. I've worked closely with business partners, human resource professionals on a broad range of employment law matters. As you all know, since the pandemic, most regulators were really largely focused on navigating through the ever-changing COVID-19 restrictions. And employers obviously spent considerable time working through both state and federal compliance challenges related to COVID. That involved vaccine requirements, remote and hybrid work policies, accommodation requests, and the intersection of those laws with state and federal leave laws. Well, here we are in 2023. We've successfully navigated through the pandemic. While you were grappling with the impacts of COVID over the past few years, regulators and legislators really shifted their focus to enacting a myriad of new employment laws. This webinar should give you a great summary of the 2023 legal landscape and how it may directly impact your business. The goal is to make sure you're up to speed on recent developments and ready to address them if they apply to your business. Fortunately, Leon and Stephanie are knowledgeable compliance advisors and can help your business address and change your business that you may need to take a look at. And I look forward to working with both of them and answering your questions today.
Thank you, Laura. We're definitely looking forward to discussing this topic with you. And before we proceed, we want to ensure everyone can hear and see Laura clearly. If you have any audio issues, please check the volume on your computer or mobile device. If that doesn't solve the issue, just let us know in the chat and we'll work to improve the audio as best we can. Now, let's take a look at today's agenda. Leon?
Yeah, as Laura's mentioned, today's agenda focuses on providing an overview of the various legislative action and employment law initiatives that will have the greatest impact on U.S. employers in 2023. We'll start off with the most pressing wage and hour updates impacting workplaces this year, including pay transparency laws, worker classification and gig workers, and a proposed joint employer rule. Next, we'll briefly cover OSHA's expanded severe violator enforcement program. Following that, we'll review new EEOC employer obligations like the updated Know Your Rights poster and recent guidance, employee wellness and mental health, and using artificial intelligence in hiring. We'll also cover employee privacy issues. And lastly, we'll briefly discuss the Form I-9 updates and changes to employee benefits law. The webinar will conclude with Laura providing the best tips for employers in the new year and answering questions from our audience.
Thanks, Leon. And the format for today's webinar features a series of questions that we'll be asking Laura regarding critical employment law updates that will affect employers in 2023. The purpose of this webinar is to provide accurate and authoritative information on the subject matter herein. It does not constitute legal advice. The applicability of the laws discussed today may depend on your state, type of business, and number of employees. We recommend working directly with legal counsel on specific matters of employment laws affecting your business. Personnel Concepts, our webinar host, and our guest speaker are not liable for any errors, omissions, or changes in law.
Yes, and now that we've got the disclaimer out the way, you guys know the agenda. We'd like to start off today's webinar by asking our attendees a question. And this is our famous polls that we are known to come about within these webinars. And so what we would like to know from everyone in attendance, what are you most interested in about hearing today? Is it A, preventing worker misclassification? Is it B, pay transparency laws? Is it C, using artificial intelligence in hiring tools? Is it D, electronic monitoring regulations? or is it E, employee mental health? And I believe you can select all that apply. So please let us know what most interests you today. All right, while those answers are flying in, we'll continue to tally them. Get them in as fast as you can, as we do want to get to as much information as we can today. So let's go ahead and close the poll and see what we've got. Okay, so based on the results, it looks like most are interested in pay transparency laws. That is a hot button issue, and we do have plenty of that on today's presentation, followed by preventing worker misclassification. Actually, electronic monitoring regulations was behind that, and employee mental health. Also, preventing worker misclassification was in the mix there as well. So it looks like we're all across the board, and plenty of information that we'll have to provide. So thank you to everyone who responded and participated. Much appreciated. Now, before we begin, Personal Concepts is offering all of our attendees our 2023 New Year, New Laws white paper, along with today's slide presentation, equipped for note-taking, which is attached as a handout right here in GoToWebinar. Then at the end of today's session, you'll receive a downloadable certificate via email as proof of your attendance today. Also, I want to invite everyone in attendance to submit any question you may have during the presentation by using the Ask Question feature in GoToWebinar. You can pose questions in the question window. Most questions will be saved for the end of today's presentation, but those that are relevant to the subtopic being discussed will be posed where appropriate. Then at the end of the session, you'll have an opportunity to use the raise hand feature in GoToWebinar to pose a question directly to our guest speaker. And with that, let's go ahead and get started with today's presentation.
Yes, let's. So, Laura, in recent months and years, there has been no shortage of wage and hour updates in the United States affecting employers. Recently, state and local legislators have worked to expand employee rights, including enacting pay transparency laws. Laura, what can you tell us about this trend and what pay transparency laws employers may expect to hit their state next?
Sure. Pay transparency is really a critical compliance issue right now. Many of those in the audience may have already been exposed to this. Colorado is one of the first states to have this law enacted, and many of your third-party vendors and websites, Indeed, I know LinkedIn, ZipRecruiter, they're requiring that all job listings have pay transparency, which includes a range that we'll talk about here. So, several states, including California, Colorado, New York, enacted laws just last year that now require employers to disclose pay rates, either in the job listing or to a candidate either upon request or at the time of hire, depending on how the regulation is drafted. Many laws are not only statewide, but include local and citywide ordinance as well. Some examples are Flagstaff, Arizona, Cincinnati, Ohio, and Seattle, Washington. There's a lot of layers and complexities to this law, mainly because they do vary by jurisdiction. So while it's impossible to give a brief summary of what applies in each state, I've really created a good benchmark for what employers should consider in the many factors that are at play, and we'll list those and discuss those here. So first, employers are now or will soon be required to disclose the salary range for various roles. This includes the location component and will obviously vary based on experience. But you should really think about what range do you want to use, considering your midpoint, the total range of that salary based on location, and what others in the same office or in other offices are making in that role. Also, you want to consider remote work factors. The laws vary if the role is remote. There are many states, including Colorado, that have said, even if the role is not slated to be in Colorado, if you list a remote position or even a hybrid position, if that candidate could potentially land up in Colorado, all of the pay transparencies that would be required is required for those types of role. So take a look at your state and local laws too to see what you need to disclose. The other thing is you want to consider that a particular candidate pay range versus a public job listing. And really what we mean by this is you're always allowed to go above the range that you provide, but if you're providing a range, That's the expectation for the candidate, and you will need to be at the low end or in that range for compliance. You also want to consider pay equity, which I know most of you do anyway for your job listings, but to be careful and really thoughtful about what the transparency is here. So others in the same role, the location, their experience, making sure that there's really equity across the board, because this is going to be information that's public to your candidates, obviously, but will be then public to your employee base as well. The other thing to think about is whether or not you want to provide a link to your company website that includes the compensation band and benefit information. And again, this is another thing that varies by regulation. Some states require it to be directly in the job listing. Some allow you to provide the link that can give them more information on your benefits in the salary band for those roles. The other thing is to think about is total compensation. And, you know, compensation sometimes is defined as just base salary. Other times it includes total compensation, which could be restricted stock units. It could be eligibility bonus, commissions, and benefits as well. And then really the last thing is understanding what the new reporting requirements may be. Almost every one of the state pay transparency laws include a reporting requirement. And that is somewhat different than what you've been either previously reporting or may have to report going forward. California, for example, starting this year in May, is requiring employees to report not only the compensation band for certain roles, but then also to provide EEO information related to those roles as well. So, you know, pay transparency becoming much more prevalent as the years go by. Every state could be affected by new pay laws in the near future. And so knowing that employers really can stay ahead of the curve by reviewing your policies related to pay reporting and pay transparencies. And that will include, you know, working very closely with employment legal, compliance, and really your TA team that's drafting and publishing those pay requirements in job listings.
Thank you so much, Laura. That was a great start addressing the needs of our attendees. So thank you for that valuable information on pay transparency. Now, moving into federal employment law, perhaps the most prevalent wage and hour issue we've seen has been employee misclassification and the proposed independent contractor rule. Can you give us some insight into how government agencies are focusing heavily on this issue?
Sure, and this is the really critical issue is, are you properly classifying your employees? And the organizations that care about this want to make sure they're classified properly, either because they want, you know, tax information and or them to be classified as an employee for reporting purposes. So in just the last year, Department of Labor and the National Labor Relations Board focused on worker classification, and we expect this to continue in 2023. This was really prompted by a January 2022 memorandum of understanding between these two agencies. It allows them to share information and to jointly investigate potential violation of these federal laws. So the DOL and the IRS also have a similar memorandum of understanding that allows them to combine agency resources and efforts to prevent employee misclassification. So there's now this kind of streamlined process between these three agencies that are really focused on determining whether employers are properly classifying employees. So as just kind of background for what this means, it's, you know, these agencies now are allowed to share data that may raise employment law compliance issues. They are allowed to now exchange information that could lead to investigative leads or complaints filed under the FLSA. They have many joint now training materials, seminars, opportunities internally for these agencies that didn't previously work together directly on these issues. They are, you know, have now a coordinated outreach that relates to preventing employee misclassification and how they communicate with employers. And they also now are providing annual reports that are going to summarize the results that were achieved based on this new kind of investigative data model and how they're working to prevent, employment law tax violations or employment classification concerns.
And thanks so much for that insight, Laura. Now, traditionally, I'd say most employers might recognize what a regular employee is. However, there may be some gray area. It might be more difficult in those cases. And in those cases, employers want to look at what federal guidance says. Can you offer information on how employers can incorporate the latest employee classification guidance?
Sure, Stephanie. And this is an issue I'm sure as all of you, sitting in your respective rooms, this comes up very frequently. It's always been, there's always been some complexity and some difficulty and gray area on where you land on this. And part of that is just there's many factors to consider. So in October of 2022, the DOL published what's now a proposed independent contractor rule. This will determine, employee versus independent contractor classification. The proposed rule rescinds what was now the current rule. It was current as of 2021, and it favored the 2 core factor test for making these kind of determinations. This is sometimes referred to as the Trump rule, and it really focused on the amount of control exercised or retained by an employer and the worker's opportunity for profit. So that was really the 2-factor rule, or the rule you're probably using now to determine classification. The proposed rule changes this. This now focuses on what's called a 6-factor test. It's also referred to as an economics reality test, totality of the circumstances test. And going through kind of these 6 factors that an agency or court will look at to determine if you've properly classified an employee. 1, the worker's opportunity for profit or loss, which sometimes depends on their skill level. 2, investments by the worker relative to the employer's investment. And 3, degree of permanency of the work relationship. And by this, I mean, how long are you engaging these independent contractors? What the DOL and others frown upon is having independent contractor classification for long-term individuals. They view the longer the relationship, the more likely that it should be classified as an employment relationship. 4, degree and nature of control by the employer. And this is really where the 2-part current test focuses. This involves everything from, scheduling, supervision, price setting. And so all of that is, how much autonomy does the employer have, independent contractor have versus the employer. 5, the extent to which work is performed is an integral part of the employer's business. And this is, I think, a more difficult question for most people. If you think of Uber as an example, the driver's certainly an integral part of the employer's business. But if you also have an independent contractor that works for Uber, that's not a driver, that works in IT, that works in safety and security, how does that play into whether or not they're properly classified? And then 6, skill and initiative of the worker. So, 1, it's worth noting that these are just regulations right now, and this is only a proposed regulation. Courts and the agencies continue to have final say on what will likely be the final rule. And right now, they're probably going to give deference to the current regulations. Employers should be sure that the DOL will issue a final rule on worker classification this year in 2023. The final rule will only apply to federal wage and hour laws. So obviously anything, state, local ordinances and classification, particularly in California and Massachusetts, which are 2 states that tend to be more employee friendly, you should keep an eye out for anything that comes out of those states as well. They're likely to be more employee friendly.
And thank you for keeping us so informed on that, Laura. I think I have the question that's on the minds of most of our attendees that are concerned with misclassification, and that is there one factor or overarching circumstance within the test that may have deciding influence on whether a hired worker is an employee or an independent contractor?
No one factor, unfortunately, because Leon, that would be too easy. So, the economics reality test, nothing is dispositive. No factor has greater weight than any other. I do think we see, though, the DOL wants to shift towards almost everybody being classified as an employee versus an independent contractor. And here's, some of the language that's proposed related to the regulation really speaks to that. So, DOL guidelines now under this proposed rule, they really de-emphasize the control factor. So the proposed rules language related to control says this: employers may exercise control in other ways, such as by relying on technology to supervise a workforce, setting prices for services, or restricting a worker's ability to work for others. These are actions that can exert control without the traditional use of, quote, direct supervision. So that's things like assignment and scheduling. The proposed rule also urges courts to consider restrictions that result from a company's legal, safety, or quality control obligations as evidence of control. And this is language that I think is somewhat troubling as an employer, because even if you hire independent contractors, and they would fall into what we traditionally would think of a true independent contractor arrangement. They have their own equipment, they work independently and autonomously, they drive kind of how they perform their work, even though obviously as the employer, you're giving them a lot of directions. It suggests that any legal, safety, or quality control obligations will be control for purposes of classification. And that's troubling because many companies require independent contractors to go through, onboard training and annual compliance training, sexual harassment training, regulatory training, all of that would be required for you as an employer to remain in compliance. And it would still require your independent contractors, given their access to data, to go through those as well. So that's something to just keep on kind of top of mind for 2023. The specific language really demonstrates that it's aimed at the gig industry mostly, but also to other employers that learned kind of how to work around using independent contractors without controlling them.
Thanks, Laura. And in addition to worker classification issues already discussed, are there any other guidance or proposed rules that employers should expect to see finalized this year?
Yes, and really similar, a lot of overlap with classification is when you're deemed a joint employer. And, a lot of times if you have independent contractors, even if they're not on site, even if you have a very autonomous relationship, you're going to be deemed an employer for purposes of federal regulations. And, the NLRB issued guidance on this last year, when an employer would be deemed a joint employer for federal law purposes. The proposed rule really changes the standard for determining joint employer status under the National Labor Relations Act. Under the prior rule, again, current rule, a joint employer was required to possess and exercise direct and immediate control over one or more essential terms and conditions of employment. And really what was looked at before was wages, hours of work, discipline, and typically that stayed with the independent contractor or the vendor from which you use the independent contractor. They were in charge of all of those things. Under the new rule, two or more employers would be considered joint employers if they, quote, share or co-determine essential terms and conditions of employment, even if one of the employers exercises only indirect control. The NLRB defines share or co-determine to mean any, possession, you possess the authority or control, direct, indirectly, or both, to exercise the power over one or more of the employee's essential terms and conditions. It sounds like a lot of legal jargon, but here's really what it means. You are sharing, when you have independent contractors, as I read the new proposed regulations, almost everybody is going to fall under a joint employer relationship, because it would be very difficult to separate what level of control you have versus the independent contractor. Even if your vendor is making that employee a W-2 employee, they're telling them the hours they have to work, they're determining the rate of pay, etc. If they're still doing work for you in which you are also approving their hours, having them go through training, determining what projects they work on, you risk falling into this, which is perhaps inevitable. Again, on this role, not yet into law, just guidance at this point. Employers should be thoughtful, as you think about, as you engage independent contractors, who may fall into what categories. And so as you evaluate these kind of employees and your relationships with them, what actions of your current employees could be deemed direct or independent supervision that could, make them fall into this category.
Thanks, Laura. And before we move on, I'd like to encourage everyone in attendance to stay up to date by following our blog at blog.personnelconcepts.com. Moving on to another compliance area, Laura, we'd like to touch on the latest critical updates in federal workplace safety law. What can you tell us about OSHA's latest enforcement efforts?
In September of last year, the DOL expanded the criteria for what they consider and characterize as willful and repeated violators. And there's now this program, I guess is the word, program that they've created that is the, OSHA Severe Violator Enforcement Program. And really what this means is they're focused on kind of repeat offenders, for lack of a better term. It targets employers that, repeatedly expose workers to recognized hazards and they've found violations before. And it really broadens the scope. So, more industries will see heightened enforcement and inspections. Under the Severe Violator Enforcement Program, they've kind of updated the criteria of who would fall under this and what that means for the employer. So, any citation, 2 or more violations for willful or repeated, or a failure to abate notice on a high gravity serious violations. And obviously what that means is you could have one violation that would put you into this program if it's extremely serious, sickness, health, death of an employee based on a workforce practice. The inspections are also going to be more frequent. Typically it would be a 2-year inspection period. They're under this program, if you fall into it, inspections could be within 1 year, sometimes even shorter, as we've seen. And while there are kind of some eligibility requirements you could meet to be removed from the program, typically you're going to spend 2 years in this program, so double the time you would before. So obviously just be thoughtful as always about any potential OSHA violations, because we are seeing some increased enforcement here.
Yes, yes. Thank you, Laura, for that timely heads up on OSHA's latest enforcement efforts. And now I want to remind our audience that if you have any questions about any of the topics, please continue to submit those in the question window. But for now, we have a question for you. So let's get started on our second poll. And we'd like to know, based on a recent workplace mental health framework, which of the following tips would you like to learn more about in 2023? Is it ensuring a physically and psychologically safe environment? Is it fostering positive social interaction and relationships? Is it finding and encouraging work-life balance? Is it letting employees know they matter and make a difference? Or is it creating opportunities for workers to attain goals and grow? Please look over those answers and select the best answer based on your business. And it says there you can select all that apply. So if you have many different goals in this area, please let us know. All right, go ahead and get those final answers in. We'll wrap it up and see our results here. And once again, we're all across the board, with the leader being letting employees know that they matter and make a difference. You guys are also interested in work-life balance, creating opportunities for attaining goals and growing, social interactions, and ensuring physically and psychologically safe environments. So pretty much all across the board, you guys are very interested and invested in the mental health of your employees. So as many employers may be aware, the EEOC recently unveiled a required poster update that replaces the previous EEO as the law poster. Now, many of you have contacted me about it. Now, Laura, what more can you tell us about this poster and any critical guidance clarifying equal employment opportunity laws?
The new poster was issued in October. I know Leon said many of you reached out. If not, Personnel Concepts has the updated poster. Here it is. It does look very different. So you may, when you first may have seen it, you thought there were probably some significant changes. I will say it is mostly just aesthetic. There is a new QR code that's included, so employees could use their phone to get on the QR code. It takes them directly to the EEOC site, walks them through how to file a charge or just to get more information with respect to any potential EEOC claims. Otherwise, it just replaces the previous poster. Make sure it's posted in requirements as you were doing before. It needs to replace your previously one, but nothing new as far as kind of substantial changes to the law or the information included on that poster. What is new is the EEOC issued last year, they called a resource document, so different than the required posting of these kind of workplace posters. It relates to service members and veterans. So that is called Protections Against Employment Discrimination for Service Members and Veterans, long title. It was issued in November 22 of so last year, and really it was jointly authored by several agencies, including the Office of Veterans Affairs. It's a document that details any federal laws and guidance that provide workplace protections specific to service members and veterans in a single publication. So it's a good resource for you as an employer. If you have service members and veterans, it's an easy thing for you to give them all in one document and provides them a lot of information.
Okay, thank you, Laura, for that overview on critical anti-discrimination guidance. And like Laura said, Personnel Concepts is here to help with poster compliance. So if you have any questions, please reach out to a compliance specialist today through our customer service line. And moving on, we know that mental health and workplace wellness became more pronounced during the pandemic. What are the latest compliance guidance and updates on mental health, and how can employers avoid related discrimination?
As most of you know, mental health, workplace wellness is just a critical focus since COVID, really. I think if you Googled any of these, you'll get hundreds and hundreds of articles, not only focused on mental health, but workplace wellness. What are employers doing and what do employees demand of their employers with respect to supporting their mental health? So while there's no new federal law related to mental health protections, there certainly is increased visibility and discussion among, I think, all stakeholders: employers, employees, regulators, legislators, agencies. The DOL did weigh in, again, not law, but guidance that I think is helpful. And so the DOL's Wage and Hour Division issued in May of last year an FAQ. It's a fact sheet, and I know that Personnel Concepts has it for you all as well. And it relates to the Family Medical Leave Act and how it discusses mental health and leaves of absence. Again, doesn't create new law, but it provides a discussion, and it has some hypothetical fact patterns that I think are just really helpful and kind of easy to understand, explaining and going through when an employee in your workforce may be entitled to job protected leave for a mental health condition or for a mental health condition for one of their family members. It's federal law, so it's specific to FMLA, but the hypotheticals may be helpful just for you to go through because state law is very similar in a lot of those cases.
And in addition to the increased focus on mental health and employee well-being, there has been a recent concern about novel artificial intelligence and algorithmic tools used in hiring and employment decisions. Laura, can you go over the EEOC's guidance on artificial intelligence and algorithmic hiring tools?
Sure. As many of you know, AI is a huge issue, huge hot button issue right now, not only for employers, but I just read an article yesterday about how colleges are determining how they will examine and review tests and essays because of all this AI technology that they think may be writing papers. So, the EEOC has spoken up on this. They issued their first agency-wide initiative related to software and AI, machine learning, any kind of tech that would cover the workplace and employment decisions. So, they continue to focus on AI and emerging tech related to how it might implicate civil rights laws. Early last year, in May of 2022, the EEOC released a technical assistance document, and that covers kind of how algorithmic hiring tools could potentially disadvantage disabled applicants. So this included that, guidance that it intends to hold employers liable for issues related to the use of technology by a third-party vendor, which obviously most employers are using. You're getting kind of off the shelf or customizable technology to help with onboarding and screening. And the EEOC has said, we hold you ultimately responsible to make sure that you're using that in compliance with the law. They gave a couple different examples about what they view as ways technology can result in disability discrimination claims. And they gave 3 examples. One, failing to provide a reasonable accommodation to applicants or employees with disabilities who would need a reasonable accommodation in order to be fairly evaluated by the tool. 2, inadvertently screening out applicants or employees with disabilities. And 3, inadvertently making a prohibited inquiry regarding a disability. And that would really take the form of having an employee disclose why they have a certain condition or what the medical information may be related to that.
Hey, thank you for that valuable guidance, Laura. Besides concerns about disability discrimination, can the use of artificial intelligence when hiring negatively impact other protected classes?
Yes, and I think one of the most impacted, at least from the EEOC's reporting, relates to age discrimination. And some of that will be obvious after we go through how they're looking at it. So the EEOC has really focused its enforcement efforts on disparate impact concerns from technology. These have been mostly race, gender, and age, with a heavy emphasis towards age discrimination. The EEOC hosted a roundtable. It was September last year, talking with other agencies, employers, and employees on what they titled AI and algorithmic fairness. And this included a discussion of what are the civil rights implications of the use of automated technology systems. This is for recruitment and hiring, but even really onboarding and evaluated employees once they're a member of the workforce. And then a discussion too of how discrimination may occur based on protected characteristics. Again, race, sex, disability, and age, as employers use these kind of hiring technologies. So they were really looking at, and will continue to look at, potential barriers to equal opportunity. And that includes issues accessing technology due to the digital divide, job advertisements that target or exclude specific groups of candidates, programs that analyze, incomplete data for, populations that have either been under or overrepresented. AI hiring tools are on the radar of many states and cities as well. We will continue to see new regulations and laws this year. As an example, New York City enacted last year a regulation that requires an audit of any, quote, automated employment decision tool used for employment decision making. Illinois enacted similar legislation. It requires both audits and data reporting from the employers when they're using this technology. California, the same. It's in draft form right now, but they are looking to impose liability on companies and third-party agencies or vendors that use AI tools that have a discriminatory impact. So definitely keep that on your radar as you look forward to 2023.
Yes, definitely. Thank you again, Laura. And before we move on to the next compliance topic, are there any other recent EEO laws employers should know heading into 2023?
There are. And so in December of 2022, President Biden signed what is called the Speak Out Act. This relates to sexual assault and sexual harassment claims, and whether or not an employer can require a non-disclosure and non-disparagement agreement related to those claims. What the legislation says is, if you have an employee that's raised a claim related to either one of those, sexual assault, sexual harassment, even sexual discrimination, it all falls under kind of the same bucket, that it is unlawful for you to require the employee to sign an agreement that includes a non-disclosure or non-disparagement clause. And this relates to pre-dispute sexual assault claims, and which is typically the case anyway. I don't think there's anything new about that. It kind of mirrors other legislation that prohibits this, but certainly keep that in mind moving forward with respect to those types of claims and releases. There were two other pieces of legislation enacted around the same time. Both relate to Title VII sex discrimination, pregnancy and nursing mothers in the workforce. The first act was the Pregnant Workers Fairness Act. This just really strengthens the requirements of covered employees to provide reasonable accommodations for pregnant workers. So this is, looking more closely and more harshly at when employers claim I have an undue hardship to change a requirement of the job for a pregnant worker or for other similarly situated employees. I don't know that this comes up that often in most workplaces. I think most employees are very thoughtful about when an employee asks for an accommodation if they're pregnant, kind of trying to work around that, mostly related to leave laws. The second act is urgent maternal protections for nursing mothers. This expands protection for nursing mothers for expressing breast milk in the workplace. It includes exempt and salaried employees. Covered employees must provide reasonable lactation breaks, non-restroom locations, the door, office that doesn't have a window, locked door, etc. Again, I think these two federal laws aren't necessarily new to most employers because you're doing a lot of this anyway based on state laws, but the goal was to make it consistent across the board. So just keep in mind, if you're not, not doing any of those things, that's looking forward, that's going to be required. Compliance on both is not immediate, but will be coming in the next year or two.
All right, thanks again, Laura. That breakdown of recent EEO laws should be very useful for our audience. And before we move on to the next segment of today's presentation, Personal Concepts would like to understand the following. This is directly related to our upcoming topic. And what percentage of your workforce is issued company computers, smartphones, tablets, or similar devices? Is it A, more than 75% of employees? Is it between 51 and 75% of employees? Is it between 26 and 50% of your employees? Or is it less than 25% of your employees? Please answer as quickly as you can, selecting the one answer that pertains to your business. And we'll go ahead and close up the poll. Please get those in. So it looks like about 36% of you said more than 75%. So a lot of administrative work that is represented here in today's webinar. And then also on the other end, less than 25%. So it could be one or the other. You guys are neck and neck. It's at 36% and 35%, and then the other percentages right there in the middle. So Laura, let's get into another compliance area dealing with employee privacy and electronic monitoring. Can you tell us about the latest privacy concerns about employers' use of electronic surveillance?
Sure, and obviously this is another issue that has come up with increasing frequency post-COVID, right? Pre-COVID, you may have had a part of your workforce that didn't have employer-issued technology, but because of the remote workforce, many have now technology-issued computers, tablets, iPhones that are a company asset and controlled by the company. So there is definitely an increased focus on any system that monitors, surveillance, employees, aggregates data on their behavior. So the federal law, kind of overall, the encompassing federal law is the Electronics Communication Privacy Act, ECPA, which you may have heard of. So this prohibits an employer from intentionally intercepting oral, wire, and electronic communications. That's everything: emails, text messages, photos, chats, unless the monitoring is done for legitimate business reasons or the employer obtained the employee's consent. This isn't new necessarily. Most employers aren't and have no interest in monitoring their employees if it's not business related. But the ECPA provides that employer provided system or any device, any assets, it's the property of the employer, and generally that you are free to monitor virtually anything that they do on any work issued device. This includes, again, emails, phones, social media activity, Gmail activity from their personal account, even if it's on their company asset. So until very recently, when states began to act their own laws regarding employee privacy, employers could easily comply with this by including the disclaimer in the employee handbook or issuing an electronic communications policy on a company asset. So, that was kind of BYOD, bring your own device to work. There were also policies on company asset communications, electronic communications, all of that. And that really covered any potential claim for improperly monitoring employee. But now, it's not enough. Is what we're seeing going forward. It's not enough to just say employees don't have an expectation of privacy in the use of a company asset and that the company has a right to monitor them. So many states have now enacted legislation that require more from employers to be in compliance. For example, New York requires written notification to employees with specific language that they are going to monitor them and a posted notice in the workplace. Connecticut, Delaware, California, very similar laws among other states it requires specific language that details what assets will be monitored, how you're tracking them, and then even explaining to employees what kind of tracking methods you are using. So definitely something to keep in mind to the extent you are monitoring employees using these kind of things.
Thanks, Laura, for reviewing current employer rights under the ECPA and how state privacy laws introduce additional employer obligations. And besides the state laws, are any federal agencies addressing privacy and electronic monitoring in any way?
Yes, the NLRB, to the surprise of no one in this room, has jumped on this bandwagon. The NLRB General Counsel in October of last year issued a memo on what she says is unlawful electronic surveillance and these kind of automated management policies. And it really adopts this new framework for addressing what they view as omnipresent surveillance and other algorithmic management tools. So really the framework suggests that certain surveillance, certain monitoring impedes the right to self-organization under the NLRA. And it really goes as far as suggest that employers using these tools, even lawfully, would be required to disclose their use and purpose. And again, when I say even lawfully, it means absent a state law that requires you to disclose this information before you use it. The NLRB's view is we think that may violate the right for employees to organize. And here's kind of the view that they have taken on this. One, they think electronic management technologies impair an employee's ability to engage in protected activity and to keep it confidential from their employer. Two, close constant surveillance and management through these electronic means threatens the employee's basic ability to exercise their rights. And then three, in the workplace, electronic surveillance and the pace of work severely limits or prevents employees from engaging in protected conversations about unionization, terms and conditions of employers, etc. So first, the framework cites what the NLRB considers, quote, unlawful surveillance or retaliation under current law. And these examples aren't new, but important to emphasize, obviously. Photography, if you're using photographs, videos of employees engaged in picketing, security footage of employees' social media accounts, if anything you're doing is in an effort to determine, are they trying to unionize? Are they talking about wages? Are they talking about terms and conditions? Obviously, that is considered unlawful. That's using the artificial intelligence or technology to screen out union supporters or to impose discipline. So that's not new. What is new here is that these types of action, when they're motivated by this, the NLRB is going to take a really harsh view of how you're using the technology. So it's really just another signal that employers should be aware that any type of surveillance, any use of technology is going to be viewed very harshly, and really be prepared to outline your business justification for using those types of surveillance tools.
Yes, thank you, Laura. And moving on to our final topic, can you briefly, and I do mean briefly, we want to get as many questions as we can before we reach the top of the hour, but please tell us about any additional employment law updates affecting employers in 2023.
Sure, and I will go through these quickly. I-9 updates is not really an update. It is just that you can continue to take and review employment verification on the I-9 virtually. This was a COVID change. It does not have to be in person. You can do it by video. That rule has been extended. You can continue to do that. New rule with respect to benefits on 401k plan. If you're the fiduciary and you're making the investment decisions, you are allowed to consider environmental, social, and governance, the quote ESG factors in those decisions, which is new. And then really a self-correction stopgap, that also relates to benefit plans is if there's been an error, you're allowed to self-correct without going through this more arduous process that was in place before. So those are really the big ones related to federal and benefit info.
All right, thanks for quickly reviewing those additional updates. I would like to remind our audience too that the 2023 New Year, New Laws white paper is available as a download in today's presentation, which features a list of all the enacted employment laws set to take effect in 2023. And before we move on to questions from our attendees, so get them in now, just remember, if they're not answered right now, we will send the answers to attendees in the coming days. No matter what, we'll get those questions answered. But Laura, do you have any final tips for employers based on the 2023 employment laws we've covered in the presentation?
Yes, I'd say 5 just overall tips. 1, pay attention to state transparency laws. Every state's going to be affected this year. Stay ahead of the curve, review your policies related to pay reporting, pay transparency, work closely with your TA and onboarding teams on this. 2, keep an eye out for the possible finalization of the DOL's worker classification rule. Keep in mind you can use the 2-factor test now, but likely to change to the 6-factor test. 3, make sure you are displaying your EEOC Know Your Rights poster, the new version of it, and including, keeping in mind EEOC regulations may change and likely to come out on mental health laws this year. 4, careful, thoughtful use of AI hiring tools and any technology, trying really to avoid inadvertently discriminating against employees and applicants. All states look like they're going to enact laws related to this, so stay alert for those changes. And then 5, on the technology front, just staying aware, any type of surveillance, monitoring technology at work will be viewed very harshly. And so be prepared to outline your business justification for those types of tools to ensure compliance.
Yes, thanks again, Laura. And before we end today's session, I'd like to remind everyone that all attendees will receive a follow-up email with a certificate as proof of attendance for today's webinar. And also, I'd like to remind you that we'll be taking the most general questions that we can today that will impact our audience on a wide scale. And so any specific questions, we'll make sure to get back to you via email. So make sure to look out for that. Now, let's take a moment to answer some of the questions from our audience that were submitted during the presentation. Stephanie, take us away.
All right. So Laura, to put you on the spot here, we have our first question from our audience. If employees are using personal mobile devices while on the job, for example, navigation apps, texting, and phone in the office, is there a requirement to compensate for this use?
There's not a requirement to compensate for the use, but you can't require them to use their personal device. So it's more likely, I think the more likely scenario should be if you're requiring the use of their personal device, it's actually required for their job, just not preferred, or something that the employee is using based on what's more convenient for them. There should be some type of policy either reimbursing for them or issuing company issued phones.
Great quick answer. Thank you so much. We have another question here. We'll just keep them going. This one's on the OSHA front. Would common owners of 14 locations in multi-locations be considered one business for OSHA reporting? The location in each state are within 30 miles of each other.
That's one I would have to look up. I will say it depends on if it's federal OSHA, it's likely to be, you're considered to be one employer. If it's state OSHA, they're likely to be viewed as different, but I would have to look up the exact distance and requirements for that.
Yeah, sure. And if our attendee that posted that question wants to elaborate on what state they're in, we can get back to them a little bit.
Absolutely, and I'm happy to
respond
via email to that as well.
We have a more general question here, which I know you'd mentioned to me in prior meetings, but what is the changing role of social media in the workplace this year?
Well, I think, as in-house counsel at two public companies, many concerns that we received were employees using personal social media not affiliated with the company and making, either comments or statements or sharing information that other employees or even the public reported as in violation of what would be kind of a the non-discrimination and harassment policy. And so, as just a bare example, right? If you as yourself personally post something on Facebook that's deemed racist or anti-Semitic, whatever it may be, and that's reported to the company, what is the company's role in addressing that behavior? And I will say, I think the trend is towards, one, if it's reported to the company, somebody knows that you're an employee of the company and therefore you're a steward of the company's message. And two, employers, I think now are, properly invested in anything that's attributable to you can be attributable back to the company. And you need to be extremely thoughtful about what you're posting, even on your own social media account. So there are many times I think it's proper and reasonable for employees either to be disciplined or even terminated for things that they're posting on their personal account when it's tied back to the company. And that's not to say, again, that you're monitoring it. Most employers aren't, nor do they have any desire to, but when those kind of issues come to you and they're representative of the company, I think we'll just see that more and more as more people are on social media and making those kind of connections.
Yeah, definitely. And to piggyback off that question, we have another question from our audience. Is the use of social media, for example, Facebook, allowed when making hiring decisions?
I'm sorry, ask that again. Allowed
in making hiring decisions from the employer's end?
That's the unsatisfactory answer is it depends. I will say typically employers, depending on the role that you are applying for, certainly if you are in a senior leadership role, if you are in a role that has high visibility, they're going to look at everything. They'll look at social media, they will look at, who you're friends with, they'll look at your LinkedIn profiles. What's not allowed is if you're reviewing social media and then excluding somebody for a reason that would be viewed discriminatory or unlawful. So that would be obviously, I saw that the individual was Black, therefore I did not hire them. Those connections are hard to make. But I think it will come up more and more. I tell both employees and candidates always assume that your social media will be reviewed. And for employers, if you're going to look at all of that, and sometimes you should, just depending on, again, the visibility of the role, to just be thoughtful about if you're excluding because of that, why, and really documenting your reason for that.
It's really good to note there. I have one more question here. I also have a question from our attendees to answer if there will be recording sent to us and about the handouts. So both of those will be emailed to all attendees and registrants. So don't worry about that. You will get that. So keep an eye out. So our last question is a two-parter here. Why employers are required to offer mental health benefits to employees? And are we at all responsible for the mental well-being in the workplace?
So the first question is providing mental health benefits. So if you have a health plan, almost every single health plan does have mental health benefit protections. Under what was previously called Obamacare is now called the exchange, that all health providers are required to have kind of minimal benefits. That includes minimal mental health benefits. So, short of that, what you are providing your employees through the health program, you're not necessarily required, again, depending on the state, to have, an employee assistance program. Some of that is required depending on where you are. But I will say mental health now falls under just kind of general health and medical. So as you think about what benefits you provide to employees, those will typically fall under that. Outside of that, you'll see, I think, a lot of highly resourced companies, public companies with thousands of employees, sometimes provide other, wellness incentives, wellness days. I think a lot have access to certain apps that promote mental health. It's not required. It's just something I think you'll see more and more employers are doing as far as attracting talent. As far as kind of responsibility for employees' mental health, I will say, I think it's fair to say there's not an increased legal requirement to ensure against mental health that was either, pre-COVID or just new with this increased visibility. I think employers are expected kind of morally from a brand perspective, from being a good corporate citizen perspective, to take more care in those decisions, and that you're likely to get more claims, more concerns. So I think kind of my best advice is to just always be thoughtful of that to the extent you can. It's not always, I understand, reasonable or feasible for small employers, but there are some things I think that can be offered through your medical plans and through just even your local incentives for employees. So hopefully that's helpful.
Yes, absolutely, Laura. Thank you so much for taking time to give those astute answers. And plenty of you all have still stuck around, but unfortunately, we are out of time, and all unanswered questions will be forwarded to Laura via email, and her responses will be sent to all attendees in the coming days. So if your question wasn't answered, just be on the lookout for that email, as we said. And thanks to everyone who submitted questions about today's topic. And Laura, thank you so much for taking the time to answer them.
Absolutely, and thanks for having me, and I'm happy to answer any questions. If you have them, certainly send them on and I'll get some answers back to you.
All right. Yes. Thanks so much, Laura, and to our audience. And we enjoy hosting webinars for our valued customers. And as such, we'd really appreciate your feedback. If you stick around for a few minutes, a brief survey will open for you to rate what you saw and heard today. And this concludes today's webinar. Thank you for attending our presentation. We hope you found this information helpful in understanding critical employment law updates taking effect in 2023. Thanks again to Laura for being our guest attorney. We look forward to continuing to work with Laura on future presentations. And if you enjoyed today's webinar, we invite you to view past webinars on demand at the link provided on the screen. And to all of our attendees, thanks for choosing Personnel Concepts as your provider of workplace compliance solutions. Have a good afternoon, everyone.
Thank you.